I'm not going to try the case today. I think, as I objected at the time of the hearing, it was inappropriate for the state's attorney's office to make the 45-minute opening statement for a trial that it made. I don't think that evidence is going to be, I don't think it exists, and I don't think it's going to be coming into trial. I'm not going to comment on the evidence in this case.
What about her competency? They say she was out in the community, no restrictions. How could she be incompetent and not restorable if she's able to just kind of come and go?
With all due respect, this is the discussion that we've been having for some 11 years. Competency requires two things: an ability to understand the legal process and an ability to assist with your legal defense. It is not that you are a potted plant sitting in the corner of a room drooling on yourself. That is not the definition of incompetency. When somebody has severe mental illness, as is not questioned in this case, and it affects one of those two things to the appropriate degree, and the doctors are the ones who opine on that, then someone is not competent to stand trial. As we sit here today, or as we stand here today, she is not competent to stand trial, and she is non-restorable.
Describe for us exactly when she was released from the psychiatric hospital and how long she was living in that halfway house.
My understanding is that she was released on or about July 9th, and she had been living in that facility without incident since that time.
Does that facility have some sort of supervisory system in place?
I believe so, yes. I can't comment specifically on it, but I believe so. Sorry, I just don't have the answer for you.
Can you comment a little bit about some of the circumstances surrounding her arrest? You brought that up here about how you reached out to state attorney.
Yeah, I mean, I have to say this. While I appreciate zealous advocacy, I was more than surprised at some of the things argued today. You heard the state's attorney of the Montgomery County say to a court, "We get lost in the law." I'm sorry, ladies and gentlemen, but I went to law school, and the law is what we have. We don't ignore the law when we want to ignore the law. The law is what we have. I found that statement shocking. I also found it absolutely laughable, as I said in court, that the state's attorney's office would say they didn't know I was Catherine Hoggle's lawyer. Every one of you knew. How do I know that? Because I'm looking at about probably 15 of you that sent me media requests after the state's attorney sent out their press release. You called me about my client. Newsweek, I don't know if Newsweek is here, Newsweek wrote to me about my client. We have dealt with each other for years after 2022. But to say that they didn't know I was her lawyer because they knew about a case that wasn't on the public record and my name wasn't in the case is absolutely laughable. When my client was arrested, my understanding is that she was arrested at gunpoint, she was taken to a facility, she tried to contact people to contact a lawyer, she was interviewed for hours. We'll find out what she said, if she said anything. This is the information I have. It is not concrete, okay? So, and they knew that she had a lawyer. It is also surprising to me, and maybe it should be to you, that they tried to get a warrant going to a commissioner who said, not enough here. So what'd they do? They threw out that case and decided to go in secret, change the story around a little bit. Mr. McCarthy told you they made a different presentation, and they went and got an indictment. That, to me, smells bad. And it should smell bad to you. Whether it's legal or not, we'll let the courts decide. But it sure smells bad.
Thank you very much.
Have a nice day.
sit down. You got going? Good afternoon. My name is John McCarthy. I'm the state's attorney for Montgomery County. As I've said many times publicly about this case, we remain dedicated to this case because we lost 2 children. And the comment that was just made a few minutes ago, and my comment about let's not lose sight of the fact that there are 2 children involved, which is a comment I made in open court, is because I think that directly relates to dangerousness in this case. And that was the context within which that comment was made. This had nothing to do with ignoring the law. We want this prosecuted consistent with the law. We want her held accountable for what she's done. That is our goal. It's always remained our goal. Today, Judge Jeannie Cho, who is a circuit court judge here in Montgomery County, held Catherine Hoggle without bond. She was held without bond for 2 counts of murder. Those 2 counts of murder relate to the deaths of her 2 children, Jacob and Sarah. Jacob was 2, Sarah was 3. I stand here with Troy, the father of all 3 of the children he shared with Catherine, is still with his dad in this race. We agree strongly with some of the observations made in open court by Judge Cho. This was a strong probable cause case. That was what the judge's judgment was after the presentation in court today. That stands in stark contrast to some of the comments you've just heard. That was the judge's observation, not mine. I will also indicate that indicting a case by use of the grand jury of a murder, of the level of murder is absolutely common, and that's what we chose to do in this case. We agree with Judge Cho's finding that Catherine Hoggle poses a risk of flight. We agree with Judge Cho that she is a danger if she was released in the community. We agree with Judge Cho that there is no lesser condition upon which she can be released into the community other than to hold her. She needed to be held without bond. We also agree with Judge Cho's observation. We know that Catherine Hoggle, who has substantially, her condition today is substantially altered from where it was 3 years ago. That's what we discussed in open court for about the last 2.5 hours. Her condition is not the same. Mental health conditions are not fixed. They do, in fact, change. Look, I don't have control over whether or not she again seeks an evaluation as to competency to stand trial. But we stand ready to meet that challenge and to make that follow the law, and meet that challenge to see whether or not she is competent to go to trial. There's not been a suggestion of competency as relates to this indictment. This is a new indictment. And as a matter of law, when this case was dropped, coming up about 2.5 years ago, maybe 3 years ago, it was done by operation of law. It was not by any kind of independent determination. By law, you cannot hold somebody indeterminately incarcerated because they're incompetent to stand trial. We respect the law, and that's what happened. We didn't turn around and immediately indict this case. We didn't take any action in this matter until we learned she was released without condition, walking in the community. It took a little bit of time for us to find out even where she was. And we then sent surveillance, as I mentioned in court, we sent surveillance teams to where she was. And she was engaged in the community, doing normal things like shopping in the community by herself. I also repeat what I said in open court. One of the reasons I think that's important that she was held here today is she is on medication. And quite candidly, there are a lot of people in our community that have mental health challenges. And the way they equalize themselves and stabilize themselves to remain in the community is through the use of psychotropic medications. That's the world we live in. She is on medications. And a lot of those, she's on a lot of medications. That was mentioned, I think the judge gave a number. But in any instance, we want her, as I said in open court, We want her to be medicated properly. We want her to be treated properly because we believe that the evidence will ultimately show she is competent to stand trial now. We do not want her to decompensate. Otherwise, we will not be able to move forward. So I think one of the byproducts, and I think the judge spoke about this too, one of the byproducts of her being detained is that we're going to be able to supervise her taking her medication. And we know by history, also discussed in open court, she's not always been compliant. So you're taking an individual who, again, the charges are here involved the death of 2 children. And again, that's why we came back to it a couple times today. I think she is in a place where we can monitor her compliance, make sure she stays medicated. I think it's the best way to make sure that she is, in fact, and remains competent to stand trial in these matters. That's what we hope and pray for. I know that's what Troy wants as well. So, yeah, go ahead.
John, you said it was important to lay out the basis of this case and the judge
Right.
understood the severity of it. You revealed some evidence in court today. Can you share with us what you said in open court today about comment to an acquaintance as well as this sketch?
May I say, because our indictment did not have a description of what the facts were that were presented to the grand jury, we spoke about, in highlight fashion, some of the information that went to the grand jury, which included that on the day after, the morning after Sarah was taken, Jacob was gone the night before, Sarah was gone that day. Troy took her to a group therapy session. And at that point in time, she made a comment to a woman that was in those therapy sessions with her that she had strangled her children. We had not said that before. That was not relevant to competency. It was relevant to public safety. It was relevant to her release here today, and that's why it was brought up. I would also say we did, in fact, when she was arrested, and this was all said in open court on the record, we did find in a public office building about a block or two away from where she ran away from Troy, on Monday the 8th, we found her purse, and with her purse we also found a drawing that was done there, and it appeared to be a drawing of children being thrown into a trash can.
So what should we conclude by that, John?
I appreciate the question, but again, I'm not going to interpret that now. Obviously, at some point in time during a trial, we may argue what that infers.
Can you also address the court commissioner not providing the court commissioner declining charges, the other charges?
May I say, the court commissioner, again, as was stated by the judge, there was ample probable cause in this case. It was ample probable cause for the grand jury. I think, as I said in open court, I think no body murder cases are rare. And the commissioners are not judges. They're not lawyers. This is an extraordinary thing. And quite candidly, we made the tactical decision that we would go to the grand jury, which is, by the way we indicted this case the first time is we went to the grand jury. That's how this is the second time she's been indicted in these murders. Both times have been grand jury originals, both times.
John, can you say as you stand here today, you feel more confident that you will be able to take her to trial for the murder of these children?
Her mental condition has, based on the records and everything was discussed in open court, she seems substantially improved from where she was years ago, substantially. And that gives me greater hope that we'll be successful in meeting our legal challenge in terms of incompetency, yes. Well, may I say, I think the first step when it comes to competency, they have to file, and that's not been done. They haven't suggested that she remains incompetent. They haven't filed anything with the court. If they file it with the court, then the court will order an evaluation, and she'll be seen by a series of doctors to make a determination. Look, competency is not fixed. Competency is not fixed. There are some, look, everybody who's experienced mental illness Where somebody is today can change tomorrow based on psychotherapy, based on medications. It can change. Quite candidly, that's what we're going to look at. Where is she today? Obviously, she was, as was said in open court, she was committed because she was a danger to herself or others 2.5 years ago. She has improved because she apparently is no longer a danger to herself or others. She's free living in the community. Things have changed.
Troy, can you talk about what it was like being in that court today, seeing her once again, and just really having to go through all this change?
I don't really know that much changes, after 11 years. Like I would say, it's amazing what you can get used to. So, I mean, it's, it feels like, I guess it feels like we're in a little bit of a better place to kind of keep things moving forward one way or the other. I mean, really, the main reason I came down here is not really to say much. One, a lot of you guys, I see some of the same faces from 5 years ago, 11 years ago. Hell, there's some of you I've called just to check on your family, see how you're doing, So I just want to thank you guys for keeping my kids out there. I want to thank John for being a man who's true to his word and pushing to get justice for my kids. And I want to thank, Demetri and Mike, with Montgomery County Police Department for continuing to be there for me and my family and continuing to push forward as well. As far as everything else goes, the only thing I guess that I haven't gotten used to is watching David Felsen tell provable lies in the middle of court. And I'll get to those as we go through. So I'm not going to sit here and just disclose a bunch of information or go off on anything. But I just wanted to thank everyone and just say that, my family is definitely still engaged and we'll be releasing information as we go forward.
Do you feel more confident today, Troy, that you might get some answers and she might be held accountable?
I think that, and I want to say this loud and clear, the main thing for me is my kids. I honestly, obviously if there's justice that can be involved, then you want justice for your children, obviously. But number one is finding my children, giving them a proper place to rest. That's what I'm here for, and I think that our best chance is for what John's advocating for, which is to keep her medicated, to continue to, move forward and allow her to move forward in that way, and hoping that does get us through court. I think that in Perkins, there's no chance that we were going to find out anything. I think and I've said this from the beginning, I think we have a much better chance, from a jail cell than we do from Perkins of her saying something. Go ahead.
Have you heard the comment before about her saying to the person in the program that I strangled the kids? And do you believe that?
I originally had my private PIs get that information as well. We interviewed a lot of the same people the police were in the first few days. So, I mean, it was something that was said. I know that.
Can you talk to us about how you were feeling, hearing her attorney kind of go back, keep going on the point about competency, that she wasn't fit to stand?
You weren't here before when I said how I feel about him, were you? Yeah. Back in the day, yeah. He's a piece of garbage.
The attorney?
David Felsen's a piece of garbage.
Troy, you predicted it at one point that she was going to get out, but when you know that she was out in the community, no supervision, and she's supposedly incompetent?
No, I mean, as far as that goes, I'm not really going to get too into that right now. That's something that, we can talk about as this goes forward. I'm going to get together with my wife, my attorney, Matt, and we're going to go over some things. The last thing I want to say before I step away is there was a small mistake made. I know everyone here has the ability to edit, so if my son's name came into this microphone, please just shut that down, because I've worked hard as hell for almost 11 years to protect him. Thank you, guys.
Lindsay, did you want to say something?
Thank you very much.
I'd like to say something. Okay, then I'll use their.
Okay, good.
It's going to be the same question, basically. Are you hopeful today more so than in the past, ever before?
I think I am more hopeful today than I have been in the past, based on the progress that Catherine has made, based on her being released, no longer a danger to herself or others, and they have stabilized her on medication. We never got to that point before. So I find that encouraging.
That she could be held accountable?
Well, that's the ultimate goal. But there's a process. I'm going to respect the process in terms of competency, responsibility, or wherever it comes up, and then, you know, I'll let the process speak for itself. Look, this has been a long journey already. It's going to continue to be a long journey, and we will continue the pledge we've made to the family to try to bring justice for them.
L-A-N-D-S-E-Y or A-Y?
EY. Yes, my name is Lindsay Hoggle. I'm Catherine Hoggle's mother, and my unnamed older grandson and Sarah and Jacob are my grandchildren, who spent quite a bit of my time at my house prior to this incident. I am only going to share with you the facts. I think some of you reached out to me during 2017 and 2022 while Catherine had criminal charges. I did not speak with the press with an agreement with Catherine that she would continue to talk to me. And so during those 5 years, she never changed her stance. She had a plan because she had been gaslit by people from her inner circle that they would have her committed to an institution and take her children, raise them, and get the state to pay for it. So I'm not justifying my daughter's action. I don't know what the actions are, but I want to share with you some of the facts that have occurred. First of all, Clifton T. Perkins dumped my daughter out on July, the Wednesday 9th, 3 weeks prior to her being arrested. She went nowhere. I was not told. Her father was told 3 days later, so it seems. And so that was just, unfortunately, a major, just horrible decision that was made. I didn't agree with it. She didn't go anywhere. She went from a medium security floor straight to the outside. She went from leg shackles and handcuffs to living on her own in a dorm-like facility. So she did not elope. I was actually able to speak with her after 2 weeks. So, you know, I don't agree with that. I'm not supporting Felson or McCarthy, but I'm going to give you the facts. First of all, John McCarthy, you got the information from me that she had been released through a few sources. So that's where it came from. And I know you did surveillance, but I just wanted to let you know where the data came from. I am here to find Sarah and Jacob. Several things. One, Catherine's father and I were subpoenaed the night before the grand jury a week and a half ago to testify to the grand jury against our daughter. I was, you know, honest with them, obviously. And so I guess this is the first time for John McCarthy to have the parents of a daughter testify at a grand jury. I'm surprised why they didn't use viable police sources. That's okay. What's done is done. The second part of this is I inquired. Catherine was arrested on Friday morning. This is day 5 of custody. I've inquired. Let me back up a minute. The afternoon that I was served subpoena, I called John McCarthy's office, and they told me that they could not get him a message and he couldn't return my call. So I had nothing to do but to show up the very next morning for the grand jury. The second part is what I'm saying is that she was arrested Friday morning. I found out third hand through the home where she was that she had been arrested. This is day 5 of custody. All I've asked is get her into treatment. She's not going to get treatment in a jail. I can't say that I don't know where you would send her, but I did make the inquiry, and third hand, he made sure the meds were available. That doesn't tell me they were administered. And then also just, you know, treatment of mental illness is not just meds. It's therapy. therapy that Catherine was denied until the charges were dropped. The first 8 years, she never got therapy. So, again, she was interrogated. This is day 5. I'm still going to ask. She needs to be treated. She was held, obviously, a few days before the mugshot because she'd been crying and looked horrible, and so that's not surprising. So I'm looking to John McCarthy to explain how he can monitor her meds and her treatment in a jail. That's all I'm asking. And finally, I just want to thank everybody that supported me, even though I feel like I'm indicted on this. Again, I want to find the answers for Sarah and Jacob. I want it as much as I could ever want it. So, I thank God and the people who continue to pray and say that they will not give up hope. And I'm going to tell you one good story is that Troy's wife and I have been communicating for 3 years. We put aside the pitting of one family against another, which is the Felsen-McCarthy show, to try to find out what's going on. So I just want to applaud Stephanie for doing that. We have, laser focus. We're trying to get answers, and we don't, there's no blame. And so, again, thank you. I think it's very important for the public to know that there are ways that the system should work. I can only hope for the best, but my one request is I want treatment for my daughter and not just availability of meds in a jail. So thank you. A layperson's assessment of improvement, I don't know how John McCarthy can evaluate. I haven't seen her because I've been blocked from Perkins. So thank you.